Welcome to Smarter Drafting with AI, turning hours of legal work into minutes. My name is Randy Bravo. I'm your host. I am a legal professional with over 15 years of legal experience, and I am also a legal technology advocate. I appreciate you taking the time to be here. This session is educational and not legal advice. Do not share confidential client information. Every AI-assisted draft must be reviewed and approved by a licensed attorney. Accuracy, professional judgment, and client protection remain non-delegable. Here's what you will leave with today. 3 repeatable workflows that shorten research and drafting time without sacrificing quality. A practical prompt kit you can adapt to your practice. And a safe rollout checklist you can bring back to your firm this week. Here's how we will spend our time. First, we will pinpoint the real bottlenecks in everyday practice. Issue spotting, first draft memos, motion skeletons, discovery shells, and client communications, and set conservative targets for what AI assistants can achieve when used correctly. Next, we will cover 5 ethics and safety rules that keep your work defensible: verification, confidentiality, vendor diligence, citation discipline, and auditability. Then we will move into a live structured demonstration that takes a matter from first draft to polished document in minutes. After that, you will hear brief case studies and return on time results from solos, small firms, and legal staff. Finally, I will give you a simple implementation playbook for piloting AI in your practice, including roles, review gates, and the metrics that matter. We will close with answering general questions. A quick word on tone. Healthy skepticism is appropriate in law. Today's approach is practical and conservative. No hype, no shortcuts. The goal is disciplined speed. Use AI to produce a structured first draft. Then apply legal judgment to verify facts, refine analysis, and finalize citations and style. Volna Legal AI is the sponsor of this program. Near the end, I will share a limited offer for those who want to try these workflows in a tool designed for legal drafting by legal professionals. For now, let's get to work. Let's start with the problem and the opportunity. Let's name the problem we all feel in practice. The work that wins cases and keeps clients is the same work that eats our calendars, spotting issues from messy fact sets, building first draft memos and motion skeletons, standing up discovery shells and client letters, and then reworking tone and formatting to match the firm's style. None of this is wasted effort, but much of it is repeatable structure that does not need to start from a blank page every time. Here's where the time typically goes. An issue spotting memo can take 60 to 120 minutes. A motion skeleton with headings, standards, and placeholders can take 90 to 180 minutes. A discovery response shell runs 45 to 90 minutes. A clear client letter is 20 to 45 minutes. And when a matter is complex, those numbers trend upward. The hidden cost is the context switching and the rewrite cycle, taking rough notes, shaping an outline, and then translating the outline into firm voice with proper headings, citations, and exhibits. Now the opportunity. With disciplined AI assistance, the first draft does not start at zero. It starts from a structured prompt that encodes the role, the task, the redacted facts, the jurisdiction, the tone, the constraints, and the output format. When you do that, conservative targets become realistic. An issue spotting memo first pass in 15 to 30 minutes. A motion skeleton in 20 to 45 minutes. A discovery shell in 10 to 25 minutes. A client letter in 5 to 15 minutes. A long decision summarized to 5 key bullets in 3 to 10 minutes. You still review, verify, and refine, but the blank page is gone. What does that mean in practice? For a solo, it can return 10 to 20 hours a week to higher value work or faster turnaround. For a small firm, it reduces write-offs and outsourcing spend, and it compresses the training curve for new associates because they can start from consistent scaffolds. For paralegals, it speeds the assembly of discovery, exhibit lists, and hearing prep packets. For clients, it means communication that is clearer and faster without sacrificing accuracy. It is essential to be precise about what AI is good at and what it is not. AI is good at eliminating the blank page, transforming bullet point facts into a structured outline, expanding an outline into a coherent first draft, rewriting to match a firm style guide, generating alternative versions for different audiences, summarizing long materials into usable digests, and standardizing repetitive sections across documents. It is good at mechanical restructuring and tone control, and it is good at giving you a workable starting point you can edit with legal judgment. AI is not good at making factual findings, weighing credibility, or choosing strategy. It is not good at inventing citations or knowing the nuances of a judge's standing order or a local rule it has not been told to follow. It will not know your client's risk tolerance, your negotiation posture, or the remedies you can plausibly obtain unless you direct it. It cannot replace your duty to verify sources, check authorities, and ensure that the final document reflects the record, the law, and your professional obligations. Use a conservative rule of thumb. Aim to cut first draft time by 50 to 75%, while expecting total matter time to drop by 20 to 40% after review and finalization. That is disciplined speed. You keep the last 20% of quality, analysis, strategy, and judgment where it belongs, with the lawyer. Finally, remember the economic impact. Less time on scaffolding means more matters open per month, fewer non-billable hours written off, tighter turnaround that clients notice, and a standard of consistency across the firm that is hard to achieve with ad hoc drafting. The payoff is not just minutes saved, it is margin, predictability, and client confidence. With the problem and the opportunity framed, the next step is to put guardrails around the practice. We will cover 5 ethics and safety rules that make AI-assisted drafting defensible and reliable in day-to-day legal work. Ethics and safety come first. The goal is disciplined speed, not shortcuts. Here are 5 rules that keep AI-assisted drafting defensible, confidential, and reliable in day-to-day practice. Rule 1. Verify everything. Treat the AI's output as a working draft, not a final. Require sources for every legal proposition. If a citation is uncertain, insist on a clear placeholder like cite needed, then validate it in your research system before the draft leaves your desk. Confirm quotations against the original. Check that authorities are still good law. Make sure the facts stated actually appear in the record. Candor to the tribunal, duties of competence, and signature obligations all point to the same place. You own the final document. Speed does not excuse accuracy. Rule 2. Protect confidentiality. Never paste raw, identifying client information into a general tool. Use anonymous labels, neutral fact patterns, or redactions. Provide only the minimum facts necessary to generate a structure you can refine. Prefer vendors that allow you to disable data retention and model training. Prefer encryption in transit and at rest. If your matter involves sensitive health, financial, or minor information, leave those details out of the prompt and add them manually during attorney review. The safest habit is simple. Describe the task and the structure you want. Keep client specifics out. Rule 3. Perform vendor diligence. Know where your data goes, how long it is retained, and who can see it. Read the data use and retention policy. Confirm whether prompts or outputs are stored, for how long, and whether they are ever used to train models. Look for encryption at rest and in transit, access controls, audit logging, regional data residency options, and a clear deletion workflow. Ask for a sub-processor list and incident response commitments. Make sure your engagement letter and internal policies match your actual use. If the vendor cannot answer these basics, do not use them. Rule 4. Be transparent in your process and supervise. Adopt a short written policy that explains when AI may be used, what must be redacted, what must be verified, and who reviews the output. Train your team. If you practice before a court that requires certification of citations or disclosure of AI assistance, follow that rule precisely. In client-facing contexts, do not oversell capabilities. Present AI-assisted work as a way to accelerate drafting while preserving attorney judgment and quality control. Supervise non-lawyer assistants and junior staff who use these tools and document the review that occurred. Rule 5. Create repeatability and an audit trail. Save your prompts and outputs as part of the matter file, just as you would preserve notes or templates. Use standardized prompts for common tasks so quality is consistent across the firm. Keep a style guide that defines headings, tone, citation format, and common sections. Add a short checklist to each drafting task: facts aligned, authorities verified, quotes checked, jurisdictional rules applied, client sensitivities removed or approved. If a question ever arises, you can show exactly how the draft was produced and how it was reviewed. Here are safe defaults you can apply today. Ask the tool to avoid invented citations and to mark any uncertainty clearly. Specify the jurisdiction and the audience for the document. Tell it to follow your firm's style guide. Set a target word range to control verbosity. Request an outline first, then the full draft, so you can approve the structure before prose is generated. When the draft is complete, instruct the tool to produce a short, plain language summary you can share with the client, and then verify that the summary matches the document. Know when not to use AI. Do not use it for sealed or highly sensitive materials. Do not use it for novel issues where the law is unsettled and a wrong turn would prejudice the client. Do not use it to make strategic calls, to weigh credibility, or to opine on remedies without research. If a judge's standing order restricts or conditions AI use, comply to the letter. When in doubt, leave the tool out and draft the conventional way. The payoff of following these rules is twofold. You reduce first draft time dramatically while keeping final quality under your control, and you create a defensible process that meets your ethical duties. With guardrails in place, we can move from principles to practice and show how a structured prompt produces a usable first draft in minutes. We will demonstrate a redacted personal injury demand letter under California law. The same structure works for motions, discovery shells, or contract clauses. I will describe the prompt I use, the checks I apply to the first draft, how I iterate to improve analysis and style, and how I finish with a client-friendly summary. Step A. Build a structured prompt. The goal is to eliminate the blank page by telling the system exactly who it is, what to produce, what facts to use, and how to format the output. Here's the exact prompt I would paste. You are a litigation associate drafting a pre-litigation demand letter for a motor vehicle collision in California. Task: produce a professional first draft that I will verify. Facts: redacted and anonymized. Liability is rear end at a stoplight. Date of loss January 15th. Insured driver admitted in a recorded call that he looked down at the radio. Plaintiff is a 34-year-old marketing manager. ER visit same day. Cervical strain and concussion. 6 weeks of physical therapy. 2 weeks missed work. Economic damages to date $21,400. Conservative future care estimate $3,000. Claimant seeks policy limits if reasonable. Jurisdiction: California. Assume standard jury instructions and negligence elements apply. Tone: firm but professional. Suitable for an insurer. Constraints: do not invent citations. If authority is needed, mark with the tag cite in brackets. Avoid speculation. No confidential client identifiers. Output: letter format with headings for liability, injuries and treatment, economic losses, non-economic harm, and demand. Include a short bullet list of factual supports. Include a damages table with line items and totals. Target 800 to 1,000 words. That single prompt encodes role, task, facts, jurisdiction, tone, constraints, and output. It produces a usable scaffold in one pass. Step B. Generate the first draft and check the structure. A good first draft will open with a professional header and a concise liability summary. It will separate liability, medical treatment, economic damages, and general damages into clear sections. It will reflect the redacted facts, not fantasies. I confirm 3 things immediately. First, do the facts in the letter match the facts I provided? Second, are there any invented citations or case names? There should be none. Any needed authority should be marked with the placeholder tag cite. Third, is there a damages table with clean line items that add up? If any of those elements are missing, I correct them with a short command. Here's my typical first follow-up command to tighten the draft. Revise the liability section to focus on rear-end negligence under California law. Remove any conclusory language and rely only on the facts provided. Keep the demand firm and professional. If I want a more compact version, I add: condense the letter to 700 to 800 words. Keep headings and the damages table. Step C. Iterate for analysis and style. Iteration turns a good scaffold into a strong on-brand draft. I use short, precise instructions to strengthen analysis. Add a 2 to 3 sentence negligence analysis tied to duty, breach, causation, and damages, written in plain English, with a single bracketed CITE placeholder to California authority on rear-end collisions. To align with firm voice, rewrite in our firm style. Direct sentences, no adverbs, neutral tone, avoid cliches, use active voice, no exclamation points. To sharpen the demand language, clarify the policy limits demand. State that the offer remains open for 15 business days from the date of the letter and will then be withdrawn absent a good faith extension. To improve readability, add a 5-bullet factual support list under liability, drawn only from the provided facts. To clean the damages math, recalculate the damages table with separate lines for medical expenses, wage loss, and projected follow-up care. Include a subtotal for economic damages and a separate line for non-economic damages without a dollar figure. Present the grand total for the economic portion only. If the draft sounds too aggressive or too soft, I correct tone. Maintain a professional insurer-facing tone, firm, factual, and respectful. Remove any inflammatory language. If I need a shorter client version, I ask, create a client-facing summary of this letter in 150 words. Plain language, no legal jargon. Step D. Polish and export. When the substance and tone are right, I finish with 2 outputs. First, a companion email to opposing or to the insurer. Draft a brief transmittal email to the claims adjuster that introduces the demand letter, lists the attached exhibits in 3 bullet points, and restates the response deadline. Keep it under 120 words and professional. Second, a Word-ready version. Output the final demand letter in clean single-column format suitable for Word export, with letterhead placeholders, today's date, recipient block, subject line, headings, damages table, and signature block. No footers, no watermarks. Before I save, I run a quick checklist out loud. Facts match the record, no invented citations. Any needed authority is tagged CITE for later research and insertion. Damages math is correct. Tone matches firm style. Deadline is clearly stated. Attachments are listed. Names and identifying details are reviewed for confidentiality. 2 quick micro workflows use the same structure and are often faster than live screen sharing. Micro workflow 1. Summarizing a long decision. I say, summarize the following 20-page California appellate decision into 5 bullet points for a litigation partner. Use neutral language. Include 1 paragraph on how this decision affects negligence pleadings. Identify any direct conflicts and mark them as CITE for later research. Micro Workflow 2. Turning discovery into an issues outline. I say, convert these interrogatories into an issues outline for defense of a rear-end collision case. Group the issues under liability, damages, and affirmative defenses. For each issue, propose 2 to 3 follow-up discovery requests or deposition questions. Each of these outputs arrives in under a minute, and each saves 10 to 30 minutes of manual distillation. The point of this demonstration is not to outsource legal judgment. It is to eliminate the blank page, standardized structure, and reserve your time for analysis, strategy, and client counseling. With a single structured prompt and 2 or 3 short iterations, you will move from 0 to a polished, Word-ready draft in a fraction of the usual time. Let's ground this in real practice with brief, conservative case studies and the numbers that matter. Solo litigation practice. Before adopting AI-assisted drafting, first draft memos and motion skeletons consume most mornings. Issue spotting, 60 to 120 minutes. Motion skeletons, 90 to 180 minutes. Client letters, 20 to 45 minutes. After moving to structured prompts and a firm style guide, first drafts landed in 20 to 40 minutes, with total matter time dropping by roughly 30% after attorney review. Weekly impact, 6 to 10 hours returned to scheduling client calls, preparing for hearings, or opening new files. If your blended rate is $250 per hour and you reclaim 8 hours, that is $2,000 in capacity per week. Over 48 working weeks, that is $96,000 in potential revenue or avoided write-offs, even before you consider referrals generated by faster turnaround. 8-lawyer boutique defense firm. The partners tracked too many non-billable revisions on routine motions and discovery. Write-offs averaged 12% on fixed-fee matters because junior drafts required heavy rework to match firm voice. The firm created a prompt library for 5 common tasks: motion skeletons, discovery responses, meet and confer letters, client updates, and hearing briefs, and paired it with a 2-page style guide. First draft cycle time fell by half. Revision loops dropped from 3 or 4 rounds to 1 or 2. Write-offs declined from 12% to 7% in a quarter. Associate onboarding accelerated. New hires reached consistent quality in 2 weeks instead of 6 because every draft began from the same scaffold. The partners did not change their legal analysis. They eliminated the blank page and the stylistic drift that triggered rework. Paralegal-led discovery team. Building response shells used to take 90 minutes. Importing captions, restating requests, organizing objections, inserting placeholders, and formatting verifications. With a structured prompt and a template that enforces headings and numbering, the same shell is produced in 20 to 30 minutes. Partner review remains the same. The gain is in mechanical setup. Over 20 to 30 response sets per month, the team banked 15 to 20 hours, which they reallocated to exhibit management, deposition prep, and calendar control. The tangible benefit was fewer last-minute scrambles and better hearing binders. The measurable benefit was a steadier weekly workload and fewer after-hours pushes. Transactional microfirm, engagement letters, demand drafts in pre-litigation negotiations, and routine contract clauses consumed small blocks of time that added up. The firm standardized tone, signature blocks, and disclaimer language, and asked the tool to rewrite drafts to that style on command. Each document saved 10 to 30 minutes. At 30 documents a month, that is 5 to 15 hours returned without touching substantive review. Clients perceived faster service, and the partners saw fewer calendar bottlenecks at month end. Now the cautions, because they protect your return on time. The firms that saw durable gains followed 3 habits. First, citations were never accepted from the tool. If a citation was needed, the draft marked it with cite needed, and a lawyer inserted and shepherdized or key cited the authority using the firm's research system. Second, confidentiality came first. Prompts used redacted or neutral facts. Client identifying details were added manually during attorney review. Third, quality was measured. The team tracked time to first draft, number of revision cycles, percentage of write-offs, and client turnaround time. Those 4 metrics prove whether the process actually saved time. If you want a quick way to estimate your own return, use a conservative calculator. Start with the tasks you perform weekly: first draft memos, motion skeletons, discovery shells, client letters. Estimate the minutes you spend now and a target that is 50% lower for the first draft and 20 to 40% lower for total matter time. Multiply the saved hours by your blended rate, but only count half of that as realized value to account for slack and learning. If that number exceeds your monthly tooling cost by a wide margin, you have your business case. There's also a quality return. When every draft begins with the same headings, tone, and structure, partners spend less time line editing for voice and more time sharpening analysis. New associates and contract lawyers align faster because the prompt library and the style guide do the teaching. Clients notice clearer letters, cleaner tables, and more consistent deliverables. That is not hype. It is what happens when you remove variance from the scaffolding work and preserve variance for the judgment work. Remember what is not promised. We are not claiming better facts, easier law, or guaranteed outcomes. We are claiming disciplined speed on the parts of drafting that are mechanical: structure, formatting, tone control, and first pass prose. You will still research, verify, and decide, but you will do so with a structured draft in front of you rather than a blinking cursor. The pattern across these examples is consistent. Remove the blank page, standardize the scaffold, and keep human judgment where it belongs. The calendar opens up. Write-offs recede. Turnaround tightens. Clients feel the difference. In the next section, I will give you a simple implementation playbook so you can pilot this in 2 to 4 weeks and prove the numbers in your own practice. Implementation turns ideas into results. Here's a simple, defensible playbook you can run in 2 to 4 weeks and then scale. Start with a pilot team. Choose one partner, one associate, and one paralegal who are open to process discipline. Give them a narrow, high volume scope: first draft memos, motion skeletons, discovery shells, and client letters in matters that are not unusually sensitive. Create a short pilot charter: the goals, the allowed use cases, the guardrails, and the success metrics. Keep it to one page so people actually follow it. Set up the core artifacts on day one. Create a prompt library and a style guide. The prompt library holds approved prompts for each task. Each prompt encodes role, task, redacted facts, jurisdiction, tone, constraints, and output format, and ends with no invented citations. Mark any uncertainty as cite. The style guide defines headings, voice, sentence length, preferred phrases, banned phrases, citation format, and standard sections such as statement of facts, legal standard, argument, and demand. Store both documents in a shared folder with version numbers and last updated dates so everyone is using the same foundation. Define the quality assurance workflow. Specify when AI may be used, what must be redacted, and what must be verified before any draft leaves the team. Assign a reviewer for each document type. Partner for dispositive motions. Associate for routine letters. Paralegal for discovery shell formatting. Require a short completion checklist to be pasted at the end of each draft. Facts aligned to record. Authorities verified in the research system. Quotes checked against originals. Jurisdiction and judge rules applied. Confidential details reinserted only after review. And deadlines and response windows confirmed. Establish data protection as a habit. Do not paste raw client identifiers. Use anonymized labels and neutral facts. Disable data retention and model training where your tool allows it. Confirm encryption in transit and at rest, access controls, and a deletion workflow. Maintain an internal. Do not use AI lists for sealed matters, minors, health-related facts, or anything a court standing order restricts. Add a line to your engagement letter or internal policy that explains your use of drafting assistance subject to attorney review and verification. Run the pilot on a weekly cadence. Week 1. Kickoff meeting. Review the charter, walk through the style guide, and rehearse 2 approved prompts together. Produce at least 3 drafts per person using those prompts. End the week with a 15-minute debrief. What saved time? What introduced friction? What needs to change in the prompts or the style guide? Week 2. Add one more use case, such as client letters or meet and confer templates. Require everyone to save their prompts and outputs to the matter file. Track times for first draft and for final after review. Week 3. Tighten the QA gates. Reduce word counts, standardize headings, and trim revision loops. Week 4. Hold a red team session. Intentionally try to break the process. Ask the tool for a citation. Confirm that it returns a CIT placeholder, not a fabricated case. Feed it ambiguous facts. Confirm that it does not speculate. Adjust the prompts and constraints accordingly. Measure what matters and nothing else. Track 4 numbers and review them every Friday. First, time to first draft for each document type. Second, number of revision cycles to approval. Third, write-offs or non-billable edits on flat fee matters. Fourth, client turnaround time and any quality complaints. Use conservative targets. Cut first draft time by 50 to 75%, and total matter time by 20 to 40% after review. If the metrics do not move, adjust the prompts, shorten the outputs, or narrow the use cases until they do. Make the workflow repeatable. Name files consistently. Matter number, document type, date, version. Save the exact prompt that produced the draft as the first page of the internal file or in a prompt log. Keep a short list of approved commands for iteration, such as tighten analysis to duty, breach, causation, damages. Condense to 800 words. Apply firm style guide. Insert 5 factual bullet supports, and recalculate damages table. Consistency is what converts one-off wins into durable gains. Train for 10 minutes at a time, not in marathons. Record a 2-minute screen capture of each prompt producing a draft. Record a 1-minute clip of each checklist being applied. Store them next to the library and the style guide. New staff can get current without a meeting. Decide when to scale. The pilot is successful when 3 conditions are met. First, the 4 metrics show a stable improvement for 2 consecutive weeks. Second, the reviewers report fewer style edits and more substantive edits, which means the scaffold is doing its job. Third, no confidentiality or accuracy exceptions have occurred. At that point, publish the firm policy beyond the pilot, add 2 more use cases, and run a second 4-week cycle with a larger group. Write the firm policy in plain language. State the allowed use cases, the redaction rule, the verification requirement, the reviewer assignments, the storage location for prompts and outputs, and the do not use AI list. Include the disclosure or certification practices required by your courts or clients. Keep it to 2 pages and attach the checklist on the third. Policy that is too long will not be followed. Respect opt-outs without losing momentum. If a partner or client does not want AI assistance used on their matters, mark the file and continue the rollout elsewhere. The gains you demonstrate in other matters will speak louder than debate. Close the loop with clients. Faster drafts, clearer letters, and consistent formatting are visible. Note improved turnaround in your status updates. If you use fixed fees, explain that you are investing in process, so you can keep fees predictable while improving speed and consistency. Clients understand disciplined efficiency. This is the entire implementation playbook: a small pilot, clear artifacts, strict QA, simple metrics, short training clips, and a written policy. It is conservative, it is defensible, and it works. In the next section, we will take questions and address common concerns before we close. Next, we will answer some common questions. Question: is AI output reliable enough for legal work? Answer: treat it as a fast first draft, not a final. It is excellent at structure, tone, and organization. It is not a substitute for legal judgment. Always verify facts and authorities before anything leaves your desk. Question: do I have to disclose that I used AI? Answer: follow the rules that govern your court and your clients. Some tribunals or clients expect disclosure, others do not. Your safest course is to have a written policy. Follow it consistently and disclose when a rule or client requires it. Question: how do I protect confidentiality? Answer: do not paste raw identifiers. Use redactions and neutral fact patterns. Choose a vendor with encryption, access controls, and no training on your data. Disable data retention where possible. Reinsert sensitive details only after attorney review. Question: what about hallucinated citations? Answer: prohibit them. In your prompts, instruct the system not to invent citations and to mark any needed authority with a clear placeholder such as CITE. Insert and shepherdize or key cite the authority yourself in your research system. Question: what is the fastest way to verify sources? Answer: require a placeholder for every proposition that needs support, then confirm each one in your research database. Check quotes against the original, confirm that the case is still good law, and document the verification in your matter file. Question: when should I not use AI? Answer: skip it for sealed matters, highly sensitive facts, unsettled issues that demand original research, or when a judge's standing order restricts its use. If you are unsure, draft conventionally. Question: will this reduce my billables? Answer: it reduces time spent on scaffolding and increases time spent on analysis, strategy, and client contact. Firms that track metrics typically see fewer write-offs, tighter turnaround, and more matters opened without compromising quality. Question: how do I roll this out without disrupting the team? Answer: pilot with 1 partner, 1 associate, and 1 paralegal for 2 to 4 weeks. Use a prompt library, a style guide, and a short checklist. Track 4 numbers: time to first draft, revision cycles, write-offs, and turnaround time. Scale only after the metrics improve. Question: what about judge-specific preferences and local rules? Answer: encode them in your style guide and prompts. Specify headings, page limits, citation style, and any standing order quirks. Never assume the tool knows your judge. Tell it what to follow, then verify. Question: can I use AI for discovery responses? Answer: yes for scaffolding. Have it restate requests, organize objections, and structure verifications. Attorneys must add factual responses, check objections, and ensure accuracy and completeness. Question: who owns the work product? Answer: your firm and client do. Confirm that your vendor's terms grant you full rights to outputs and that no license is taken in your work. Store prompts and outputs in the matter file like any other draft. Question: how do I train staff efficiently? Answer: Record short screen captures for each approved prompt and for the checklist. Keep videos under 3 minutes. New hires can self-train and adopt the firm style quickly. Question: what is the malpractice risk? Answer: the risk arises from unverified content, not from the tool itself. Mitigate it by redacting, verifying, documenting your review, and limiting use to approved tasks. Your signature and duties remain the same. Question: how long until I see a return? Answer: most teams see gains in weeks, not months. A conservative target is a 50 to 75% reduction in time to first draft and a 20 to 40% reduction in total matter time after review, when the workflow and guardrails are followed. Next, I will close with a brief offer for those who want to try these workflows in a tool designed for legal drafting. Thank you for spending this time with me. If today's workflows make sense for your practice, I invite you to try Volna Legal AI, a drafting workspace built for lawyers who want disciplined speed without sacrificing accuracy. Here's what you get: style-aligned first drafts that follow your headings and voice, a simple way to iterate, tighten analysis, adjust tone, add factual bullet supports, and control length, guardrails that encourage verification and preserve confidentiality. We are offering a limited promotion for viewers and listeners. Get 25% off for 3 months, limited to the first 100 signups. Use promo code VLAI2025 at checkout. Getting started is straightforward. Go to volnalegal.com and start your trial. Enter VLAI2025 to unlock the offer. Choose the plan that fits your practice, solo or firm. Volna Legal AI does not replace legal judgment. It removes the blank page, standardizes the scaffold, and gives you more time for analysis, strategy, and client service. If that is the kind of speed you want in your practice, start at volnalegal.com and use code VLAI2025 while the offer is available. Thank you for joining me. I appreciate your work and your standards. I look forward to seeing what you build with these workflows.